witness harm, intimidation, and interference.
Witness protection seeks to protect a person with vital information that's going to be considered in any case as evidence. This can be during the time of investigations, during and after the investigation of any case. But what does this involve?
Giving of testimony behind screens, having hearings in camera, having video link testimony, not divulging to other people who are there that they have identified this person who they believe is going to be a witness.
Use of code names. In some cases, like the war crimes case of Thomas Koyolo, we've had to camouflage some witnesses.
Protecting a witness at times goes hand in hand with protecting his or her relatives, which becomes costly for the case to be prosecuted.
Changing the face of a person, relocation of a person to a different jurisdiction. We use anonymity so that people don't find out who this person is. There are some facts that can already be removed, facts that would identify a person who is going to be used as a witness.
In cases where psychosocial support is not provided to witnesses, some may not even recover from the psychological problems that they experience at witnesses. Witnesses will claim contrary to their statements.
In cases of organized crimes, trafficking in persons, cybercrime and terrorism, this has been hard for the DPP's office to prosecute such cases, which in turn hinders justice to both the accused, victims and the public, thus leading to an increase in case backlog.
Particularly the youth who are trafficked to Asian countries, when they return to Uganda, try to pursue cases against the perpetrators of these crimes, make a lot of threats to them, and this is aimed at derailing them from pursuing justice.
In investigation, we talk of evidence, exhibits, and proof beyond reasonable doubt. So connecting these two, it becomes a challenge. So as you prepare a file, you realize you have to protect the informers. There are these children who are victims.
The absence of a witness protection measures with the criminal justice system leaves witnesses with no sense of safety, especially when the perpetrators of serious and organized crime happen to be the state actors or politically exposed persons.
We understand the state has a higher burden of proving a case beyond reasonable doubt. But at the end of the day, the balance of convenience on convicting innocent people as against acquitting probably people who committed crime. Where is the balance here?
With the need to have the Witness Protection Act, the issue at hand was addressed to the head of state.
The laws of protecting the witnesses, I didn't know that this was a problem. So if it is a problem, the Attorney General, you should work on it, the laws to protect the witnesses.
You would not know the motivations why a person is giving evidence. It cannot be left in the hands of the state to determine on how to control. So the state will be in full control of the trial.
In 2023, the DPP's office launched the prosecution-guided investigation guidelines aimed at guiding police and those involved in investigations on how to carry out investigations, mainly in criminal and capital offences. Although with the existence of the guidelines, the DPP's office say, with the enactment of the Witness Protection Act, the guidelines can be enforced to ease prosecution of cases.
It's important to fully consider witness interests, since their importance in highlighting facts and evidence trial in the courts of law cannot be understated.
In the mind of the prosecutor in Uganda, anyone brought before them is guilty before they are proven as such. Now with such a prosecutorial mind in Uganda, then this will add salt in the wound that we've been suffering from.
So I think the beginning point should be on us having a credible police, a credible investigative arm, such that when the cases are being investigated, we know that we have incredible people who are investigating them.
According to the police report, 10,345 cases of threatening violence were reported by witnesses and victims of crimes. Among these cases, 35% were related to intimidation of witnesses and victims who were waiting to give evidence in court.
The aftermath of intimidation or even crime leaves witnesses with profound retention.
No one would not want a prosecution against a criminal. Convicting one innocent person, you'd rather release 100.
As the process of enacting witness protection law takes a snail pace, legal minds have divergent views on the act.
It is a public secret that we have police which is full of corruption, which has so many corrupt officials. Someone is given a file to investigate, deliberately mishandles the file, makes the evidence disappear.
Now they want to bring it to these other ordinary matters, and I think it will lose meaning. The test would be of the evidence, the quality of evidence would go back to why, what is the motivation. You cannot get the motivation of a person testifying against the other when that person is hidden from the public.
Article 28(1) of the Constitution provides that in the determination of civil rights and obligations of any criminal charge, a person shall be entitled to a fair, speedy and public hearing. As the processing of the act hangs in a balance, where does this leave Article 28(1) of the Constitution?
Criminal matters are public in nature. That's the only way a person who has something against such a person's character in a trial often in time determines the nature of evidence they give.
If someone to enjoy a fair hearing needs to know the nature of the allegation made against him, the nature of the witnesses who are coming to testify against him, the right to know those witnesses can only be taken away in limited circumstances.
In some capital offences, prosecution has advocated for witness protection, like in the case of legislators Muhammad Segiri and Alan Sawanyan and 5 others, Thomas Koyero, all cases in the International War Crimes Division Court.
Any witness would really deserve protection, but that a person can be coached to be a witness, like we've seen before. Just in case if Chakwa had gone under the witness protection, then high evidence would have been on record and probably it would have led to a conviction against Dr. Kiza Besigye.
In the attempt of someone hiding under the witness protection, we are going to have so many trumped-up charges because someone is well assured that his identity is not going to come out.
With the empowerment of the criminal justice system, legal minds, however, don't see the need to enact the law.
Whereas it may be pertinent that witnesses must enjoy some level of protection, at the same time, it is important that there is a balance between the rights of the victim, the rights of the witness who is coming to court, and the rights of the accused person.
Let's start with first things first. Let this country work on institutions being independent. For as long as the institutions are independent, they can stand alone, then we can come out to support it because no one supports crime in society.
Deborah Namamonde, UBC News.